Good morning, ladies and gentlemen, and welcome to another episode of PLA with myself, Nick, and Bruno. We've got two questions for Nick today. Both are related around the CPA, so we're going to rope them into one. We'll be discussing when does the CPA apply and when does it not apply, and different sections of the CPA that could be considered in these questions. The first question, Nick, with regarding to this specific section is, if a student who signed a fixed-term lease agreement cancels the lease after she moves in, all right, is she obliged to pay the full-term lease when the contract says that when you sign a lease, you are agreeing to pay for the full 10-month period and the lease may not be cancelled? So is this acceptable in terms of the CPA? And as soon as you answer that one, I think I should jump into the second one right now so you can do a quick contrast. So the second question then on the opposite end states that this person would greatly appreciate our insight. And then approximately they state that 4 years ago, they allowed a friend and his son to move into a separate room in their home where they stayed with, where he stayed with his son, and they had an informal agreement with minimal rent. Unfortunately, over time, the friendship and the tenancy sort of deteriorated after certain relationship breakdowns, right? And then they've now provided them with a 1 month notice to vacate the premises. Given the strained relationships and potential for non-compliance with that move-out date, they're a bit concerned as to what are their rights in terms of protecting themselves as the homeowner, and any legal steps that they can take in terms of the eviction process should the other tenants not move out on the due date. So, Nick?
So let's talk about Section 14 of the Consumer Protection Act, okay, as a whole. So Section 14 of the Consumer Protection Act relates to fixed term agreements entered into between parties. All right. It's not a provision that is specific to our industry or lease agreements in any particular way. It relates to all fixed term agreements that might fall within the ambit of the Act. Okay. And Section 14 deals with cancellation of fixed term agreements that are entered into between parties, okay? And specifically, it gives a right for a consumer to cancel a fixed term agreement, okay, giving notice to the supplier or the provider of a particular good or service, okay? Section 14, okay, therefore gives one a right by giving a 20 business day written notice to the other party to cancel a fixed term agreement. In our industry, in the legal, in the housing industry, this includes fixed term lease agreements. Okay. Now, what's important is the Act doesn't set out what a fixed term agreement is. Okay. The legislature, when drafting the legislation, was clever in the sense that they don't know what a fixed term agreement is. It could be anything, circumstances, because as I've said already, this doesn't specifically relate to leases. It relates to all contracts that are entered into for a fixed term period. So take, for instance, our industry, we've got lease agreements. Are they for a fixed term period? Well, if you set out in the agreement it's for a 2-year period, yes, that's a fixed term. This also covers contracts like cell phone contracts, okay, which are also, it's a completely different contract. It's a different service that's being provided, but it can also be entered into for a fixed term, 2 years, okay? Imagine supply of goods. You know, you get coffee for your office and you sign a contract with your coffee provider. Again, it can be entered into for a fixed term period, i.e. in that contract, you are setting out a specific period for which that service or good is being provided to one another. Okay. There's no particular definition, and the legislature has left this open on purpose because there are a wide array of different services and goods that are provided within our economy, and the legislature wanted to try and encompass as many people as possible. All right. So Section 14 is simply a mechanism for people getting out of contracts that they might have entered into, okay? And there is a penalty which comes along with that, okay? So you might have a damages penalty which you have to pay in the circumstances if you do cancel the contract, but there is a mechanism which the law provides that you can cancel that agreement during the fixed term of the agreement. Okay. What you will know from this now is any agreement that doesn't have a fixed term, i.e., it's running on a month-to-month basis, okay, or it's a single use sort of agreement. You're only supplying something one time to someone. Okay, Section 14 is not going to come into application. All right, you're not going to use Section 14 to cancel the agreement, and this is practical. Okay, if you have only entered into a contract where you are getting the delivery or a service one single time, it is impractical that you need to give 20 business days notice to cancel the agreement. That doesn't make any sense. Okay, so in those circumstances, don't worry about Section 14. It's absolutely not going to apply to your circumstances. Now, in terms of question 1 for today, they say that there was a contract for 10 months that's been entered into. Okay, that in terms of law is a fixed term. So you can already see from what I've mentioned earlier that you need to start looking at the CPA to see whether Section 14 is actually going to apply to that particular transaction, but it seems that they will. Okay. The other thing that's set out in that particular question is it says in the lease agreement that the Consumer Protection Act doesn't apply, or at least that the tenant can't cancel the lease agreement early. Okay. An agreement to say something like that, okay, is going to be in contradiction with legislation. So the Consumer Protection Act says you can cancel in certain circumstances. If your agreement says that they can't cancel under any circumstance, okay, you cannot contract out of legislation in the circumstances. They're still going to have the rights that are imparted on them by the Consumer Protection Act. Right. So just to deal with that question, can they cancel? Yes. In terms of the Consumer Protection Act, it seems that they're going to be able to cancel. Are the consequences? Yes. Penalties in terms of Section 14. Okay. Now let's contrast that with the second question that we received. Okay. Someone let someone reside within a particular property. Okay. It's a friend in the circumstances, and they have been given occupation of this premises, but it doesn't seem to have been for a fixed term. They didn't say you can stay here for a year. They just gave them occupation of the premises, and they did say that there's a little bit of rental being paid, but not much in the circumstances. So what we have here is a fundamentally different sort of agreement. Because it's not for a fixed term, okay, you can already see that Section 14 of the Consumer Protection Act is not going to apply to this particular relationship. Okay, it's running at best, from what I can tell from the facts of the case, it's running on a periodical basis, i.e., it's running month to month, depending on the rental, when the rental is due to be paid. I'm assuming that it's a monthly rental of some kind. Okay, but the point is that Section 14 is absolutely not going to apply to the circumstances because there's no fixed term agreement. All right, and this is the massive distinction that you must have in your mind when it comes to, does Section 14 apply to my particular transaction, and therefore can they give a 20 business days notice to cancel that particular agreement. Remember, this isn't exhaustive of the ability for one to cancel a lease agreement. So in the second question, they've said they gave a month's notice for them to vacate. Absolutely perfect, sounds right. Okay, there are other ways that agreements can come to an end, breach, termination, etc. But for the purposes of Section 14 and understanding Section 14 a bit better, look for your fixed term agreement. That's the first thing that you need to determine before you can do other inquiries on cancellation, termination. Even Section 14 doesn't apply to every single transaction. There is an exclusion in Section 14.1 between transactions between juristic entities. So if you've got two companies that are entering into contracts together, it might be that Section 14 doesn't apply at all, regardless of whether this is a fixed term transaction or a periodical transaction. Okay, but for the purposes of distinguishing what you're dealing with in the circumstances, look for whether an agreement is fixed term in the circumstances.
Right. Yeah. So thank you very much, Nick. So a clear distinction there between the two questions where Section 14 of the CPA would apply. Thank you once more, Nick, for making that clarification for us.